I was sitting in the back of a citation day once, and they called the case with a 1986 index number.
This is critical for you, those
Yes.
who don't have a will, and you think everything's going to my husband or to my wife. It doesn't.
It doesn't. Your kids are involved.
This is the kids are minors.
It's a total nightmare. That's where your issues begin, because kids cannot collect assets until they're 18.
Right.
It is a headache that even I get frustrated with.
Right. Now, what you're talking about is totally avoided with a trust. Now,
honestly, what a trust is just a will on steroids.
Right.
It disposes of your assets. It names who you want to be in charge.
Welcome to the Unlocking Senior Resources podcast by Leave the Key. I'm Larry Wagner, and I've spent 30 years working with seniors, where I was a certified senior advisor, and the last 15 years in the home buying industry as a certified senior transition specialist, where I specialize in dealing with seniors going through a transition in their lives. This podcast is for seniors, those with seniors they love, and people who work in the senior community. In each episode, we bring on a guest who works to improve the lives of seniors. This podcast is your key to unlocking senior resources. Today we're here with Clay Snider of Sammartino and Sultan, attorneys, lawyers?
Law group.
Law group, there you go. How are you doing?
Good. Thanks for having me.
Well,
excited
welcome.
to be here.
That's very good. We had Leslie Sultan has been on the podcast before, but you'll come with a different angle because you deal with probate.
Yes.
I would say almost exclusively. Is that a fair way of putting it?
Pretty much. I
Pretty
will
much.
still handle some estate planning as well, but I am the head attorney on our probate matters.
Oh, very good. So how did you get to become a attorney specializing in, well, I'll say specializing in probate?
Yeah, it was a long way coming. I was a little bit of an older attorney when I got admitted.
You don't look old enough to be an older attorney.
I know. It's funny, but I was one of the older people in my law classes.
Really?
So, yeah, just by a couple of years, nothing crazy.
Okay.
But I worked for a personal injury firm after college. I went to Buffalo. I graduated with a business degree, and I started working for a personal injury firm, doing finance for them, just their back end stuff and pushing checks out. And I did that for about 3 years, and I pretty much just decided COVID helped accelerate the process. It was, after seeing it for 3 years, I can definitely go and be an attorney, and this was a good time to do it.
There you
so
go.
I went to law school starting 2021, and in law school, I did an externship with the Elder Law Clinic.
An externship?
Yes.
I never heard that term.
Yes.
An externship. How is that different than an internship?
So internship would be like an outside firm. And
Right.
externship it's an in-house in our school program.
Okay.
So there's an attorney in the school who runs free services for those who need it.
Right.
One of those areas was elder law care.
Right.
And so what she does is supervises students to get hands-on experience with clients.
My son went to Northeastern co-ops where he actually worked in different businesses. And so he got professional experience. He got paid for it, though.
Right.
So you didn't get paid
We
for
did
that.
not.
Yeah, you're a lawyer. You get paid later.
Yes.
So anyway, but that's interesting. But externship, I never heard
Yes.
that term.
So
Okay.
that's where my involvement with elder law care in
Right.
general got started.
Right.
After that, I did an internship in the
Right.
summer at a firm and liked it again. And then I was like, you know what? I really like this field. And
Right.
I eventually got linked up with Christina and Leslie.
There you go. As a financial advisor, I did a lot of work in the estate planning process. And it was fascinating because it's really, everyone thinks it's always the same. There are a lot of similarities, but there's always differences.
Yes.
And
it's always unique to the person that
is.
comes to you. There's always little intricacies. Everybody always has something a little different.
Right.
It's very rare you see the same thing kind of
Cor-
twice over.
The entire story
Right,
the same.
the entire story,
Right.
yeah.
I say it's like a puzzle.
Yes.
And it's how you put the pieces together. And, if you put it one way, it looks like something. Another way, it looks like something else. You have the same pieces. Just which piece you're going to use for this puzzle. And I found it fascinating.
Yeah, it's always funny because then the funny ones are where the client is hiding a piece, right?
Yes.
They don't know or they forgot, and then that's how that's when you really start kind of lawyering a little bit.
Correct.
It's like
I broke the cardinal rule in my own podcast. I didn't turn off my phone.
I checked beforehand.
There you go. So anyway, that's very interesting. But you're right that people sometimes don't even give you the whole story.
Sometimes they don't know the whole story themselves.
I was just going to say it by accident
Yes.
more often than probably not. I totally believe that.
Yeah.
I totally believe that. But today we're here to talk about probate, but specifically, we've talked about estate planning on the podcast because there's so much to talk about. But probate is like the nemesis of every person who has to deal with a deceased parent or spouse. But should it be?
Yes and no
Okay.
is probably the best way to answer that. And
Okay, that's the end of the podcast. Okay, go ahead.
well, I think the part of the problem is that the older generation,
Yes.
no slight to anybody,
Right.
was told for years you need to do a will because 70s, 80s, 90s was, the trust was for the 1%.
Yes, the wealthy.
The wealthy, the wealthiest guy in your town may have a trust type of thing.
Yeah.
And that was true at the time because trust law was kind of up and coming.
Right.
It was not as dominant as it is now
Yes.
and well thought out. So they weren't wrong in thinking that then, and even through the early 2000s. But now trusts are just so much better, and I'm sure you've had guests who've talked about that.
Yes.
I could talk about that. They are so much better, and unfortunately, the older generation, as they age, continue to stick to, we need a will, and you just want a will, and we don't want to spend the extra money for the trust. And that's where you run into issues with probate, because then you have to tell these people, well, you're going to have to go to probate, and your kids are going to have to find an attorney to probate, because probate in New York is the hardest probate there is in the country.
Is that true?
That's my understanding.
I always think California may be a good
Maybe
competitor.
California, but,
right, yes.
But they are always kind of
The
on
whole
their own.
Northeast, the whole Northeast is a pain, but usually New York and California win the awards
Yes.
for being most difficult.
Exactly.
So with that said, so just to create the distinction, if you have a trust, there is no probate at all. Assuming everything, which it never is, everything's in the trust. In a perfect trust world, there is no probate.
Yes, ideally, yes. The main purpose of the trust, both trusts,
Right.
revocable or irrevocable,
Right.
is to avoid probate.
Right. So I'm going to ask you one question, then when we get to let's go to probate question. How many people who write trusts don't have to go through probate for any of their assets?
That's a hard answer.
Right. I don't expect the real answer. Is it a lot, a little, many?
I would say a lot.
I would think a lot too.
If you are able to present to your attorney
Right.
your whole entire
Mhm.
financial picture,
Mhm.
it's rather easy, unless you have some complicated asset,
Right.
to set them up to make sure they avoid probate.
Right. Right now, I had a closing. I'm in real estate. I buy houses, and I just had a closing yesterday at 5:00. The title closer said, "Wait a minute, who is the owner of this trust?" And he said, "Larry is." She goes, "I have Ben. Ben's my son." He goes, "That's wrong. It's Larry's trust because I own my company, which owns the houses. Excuse me, I own the trust, which owns the company, which owns the house." I'm not sure I'm saying that properly. The trust owns the company, which owns the houses.
Yes, the
leave me
trust
out
owns
of
the
leave me
company.
out of that altogether. Right? I said that's not going to work. That sounds like a probate error. So with that in mind, we created another half hour of dialogue.
I'm
so
sure it did.
having trust isn't always without its issues as well.
Yes, we specialize in the Medicaid Asset Protection Trust.
But I hear a lot of that. Yes.
Which is basically just sets you up to avoid probate and also make sure that a nursing home
Right.
doesn't eat everything that you've earned to pass down to your kids.
Yes.
There are other versions of irrevocable trusts where credit shelters and stuff like that
Yes.
we do, but we mainly focus on nursing homes and,
Yep.
and Medicaid.
When I was in the
asset protections.
business, I was in the financial business in the 90s, credit shelter trusts. That was it. 1990, I went in credit shelter trust. 91. Credit shelter trust, credit shelter trust. That
Yes.
was about everything. Yeah, the $600,000 exclusion and so on. But let's focus on probate.
Yes.
So let's first discuss what is probate.
So probate itself is when someone dies with a will. It's the process of filing the will with the courts and everything that comes with a court proceeding. Service on distributees, which we can get into in a little bit,
Yep.
and so on and so forth. And then there's also, it's generally just called probate, and it kind of just encompasses everything. But in reality, the courts break it up into probate, which is with a will, administration, which is without a will, and then there's some niche other areas.
Oh, I knew the two.
Yes.
Okay, I was going to
There's-
say mention
There's
administration.
a
Okay.
voluntary administration in New York, at least. That's $50,000 and under.
Oh, that's interesting.
and it's
Right.
cheaper and it's faster usually.
So that's if there is no will?
You can use a will to guide a voluntary administration.
Yeah.
Yes. So as long as your assets are under $50,000,
Right.
you can go with the voluntary administration
Well, that's
route.
interesting. I had never heard that term.
That helps trusts out a lot because if you miss just one asset in trust,
Oh,
you can only voluntary administrate. You don't have to do a full proceeding,
if
which is nice.
if my car's not in the trust,
Right.
then the kids go to sell dad's car. Got it.
Best way to think about it is the one bank account.
Right.
I forgot the one bank account with $15,000 in it. How do I get access to it? And it didn't have beneficiaries, of
So
course.
my will, because my trust is written in such a manner, which is probably just boilerplate, that any of my assets can be put into my trust after my death, and they consider put in my trust prior to death. Is that's a legitimate clause in the trust?
Yeah, I think what you're referring to is an assignment of property.
Oh, you could, okay.
And we typically we do those on all trusts. So it's everything that I own, because you're putting the house in trust almost always.
Right.
It's your largest asset. It's almost always going into trust. And then we just have like a little rider page of called an assignment of property that says also everything inside of the house and kind of on the property is a trust asset as well. So it just allows you, it kind of covers your bases. If you have that painting or that jewelry with a certificate of who the owner is, and they give you a hard time trying to sell it, you can use the assignment of property.
Right.
That's where the cars can kind of get involved.
Got it. Well, I have none of that.
Everyone says the same thing.
No, but I really have none of that. You can go through my house. I have insurance for my contents. I'm saying there's no way, because that's always a percentage of the value of a house.
Yeah.
Not even close. Most expensive thing I own is my table saw. So, So anyway, putting that aside, and it's not even in my house, but putting that aside. So probate is the process of probating a will.
Probating a will.
Okay. And an administrator is basically distributing the estate without a will.
So when you get granted probate, when you you finish it, you become the executor of the estate.
People think you're the executor in the will.
Yes, you're a nominated executor.
Exactly.
But the court has to appoint you.
Yes,
So
correct.
they
The
have
court
to
has
do
to say
the-
the will's okay.
Yes.
We agree.
Yes.
Okay.
So that's when you get a will through probate, you become the executor. When you do an administration, you become the administrator.
Right. Same role.
Same role, same power, same everything, except you don't have this document that is dominating what you need to do, right? So like a will can say everything to Larry.
Right.
And then if you as the executor, you have to give everything to Larry, or else you break your fiduciary duties as the executor. Administrator is a little different. Administrator, New York State determines who gets what. And they have a very set order. And it's rather simple. It's spouse and kids with a spousal exemption on top of that of $50,000.
Wait, listen to this. This is critical for you, those who don't have a will, and you think everything's going to my husband or to my wife. It doesn't.
It doesn't. Your kids are involved.
Yes.
They have to split everything 50-50. Your husband will absolutely, or spouse or wife will absolutely get 50% of your estate. However many kids you have will split the other 50%.
Right.
But before that split even happens, the surviving spouse gets $50,000 immediately right off the top of it.
So if you have, I used the example of $1,050,000.
Yes.
So the surviving spouse gets $50,000. The 5 kids get $100,000 apiece.
Correct.
And the surviving spouse gets $500,000.
Right.
Surviving spouse does not get $1,050,000.
No.
And they get $550,000, or he or she gets $550,000. And now, if the kids are minors,
Yep. And
what
that's
happens?
the rub.
Yes. then it goes into a trust with a.
It's a total nightmare. That's where your issues begin, because kids cannot collect assets until they're 18.
Right.
And if you have minor children, you can't just administrate and then hold the assets for them and tell the court, I will take care of it when they're 18. It doesn't work like that. You have to first petition to be the property management guardian.
I was going to say the guardian of your own children.
Your own children.
Yes.
Basically, the court has to approve you to hold the money for their benefit, or hold the asset for their benefit until they turn 18.
Does the court ever say no?
They give you a very hard time, as you could imagine, because it is a guardianship's no joke.
Right.
No matter what kind of guardianship it is. And it's just a lot. You need to produce a ton of documents. I have multiple cases where we're stuck in property management guardian for a year or two before we even get to the estate.
Wow. So the money's held up.
Yes, they are separate proceedings.
So question for you, using my example of $1,050,000, let's assume mom goes. Always kicking dad off.
Yes.
Let's bump in that. Let's go mom goes. So now dad's surviving with his kids. Does dad get his $50,000 to $500,000 and the $500,000 stays aside? Or none of it's distributed till this guardianship's worked out.
It depends how the assets are held. If it's a
Okay.
bank account,
Right.
he can you know what? Honestly, no. They would probably be stuck. Because what happens is these entities, banks and financial institutions will freeze you out.
Correct. That's what I'm thinking.
Yep, until you produce to them some type of letter from showing your administrator or the executor.
Right. They're not going to let you take half. Right.
Ideally, if a spouse does go,
right,
the surviving spouse is at least named the beneficiary on some accounts so that they have the money,
right,
or they're a joint owner on the accounts. Right. So that will quell a lot of those issues. But yeah, I mean, if mom who passed had a separate account,
right,
the bank, and with no beneficiaries, the bank will probably not release those funds until everything is settled.
And those other accounts would go because they're not going through probate. If it's an account with the right of survivor or a joint account,
right,
then it just automatically goes not through probate,
right.
So none of that would appeal. So in this case, mom passes, they're worth $1,050,000, and $500,000 of that money is in a joint account. Is that part of the $1,050,000? No, it would just be her half would be part of the $1,050,000.
That $500,000 that mom and dad had in a joint account, but just becomes dad's.
Just becomes dad's.
So that's nice.
So now dad gets $50,000 plus half of the remaining $500,000.
Correct.
Okay.
Correct.
It's really, you really need a will. And I said this a few weeks on a podcast, talking to someone else, another attorney was dealing with wills and trusts. And I said, people say when you have children, you need a will. I said, no, when you're thinking of having children, you need a will. Because once you get pregnant, you forget about it. Once you have a child, forget about it. Now the kids force say, I should have a will. But things happen between 1 and 4, or 0 and 4, or pregnancy and 4. And you don't want to be unprepared. As you can see, it's a nightmare.
Yeah. What I like to say is any client that comes in to talk estate planning with me is, because the two go hand in hand, obviously.
And let me correct, I said a will. Estate planning.
Yes.
I don't mean a will, estate planning. Go ahead.
But what I typically say is a will is fine, but you're going to go to probate. A trust is better.
Right. Trust is better.
But do something.
Is there a downside to a trust?
It depends what kind of trust you do. And a revocable trust, I would say, no, there's not really a downside to it. A revocable trust, you can be your own trustee.
Right.
And that's typically how we guide young parents.
Makes sense.
Revocable trust. And you basically just set up your kids. God forbid something happens to you. Don't have to do the property management guardian route. Everything can sit in the revocable trust. You can nominate your brother or your sister to be the guardian of.
Right.
They would still have to become guardian of the child for other reasons, not property management related. The property management thing can be taken care of via trust.
Right.
So if you name your brother to be the guardian and the backup trustee on a revocable trust, then your brother's in charge and he doesn't have to do anything in terms of the money for the kids.
Mm-hmm.
He may have to become their actual guardian to send them to school and sign forms and stuff, but that's a whole different story.
Yep.
So revocable trusts are typically we reserve for the younger parents.
Yep.
And irrevocable trusts are for the elderly.
Right. Now you're doing Medicaid and estate planning. Tax avoidance planning.
Yeah.
Right.
All of that.
So, although state tax is not a big deal today, I mean,
it's large these days, but
who knows?
It went up for a reason because people's assets are growing,
but it went up. I started in the business with 600,000. Then it was $1 million for a long time.
For a long time, it was $1 million, and now it's up to 7.
7 million.
7 in New York, 14 to 15 federal.
Yeah, I lost track. It doesn't matter. We're splitting hairs, 14 or 15 per member of the couple.
Yes.
So if you're married, 28 or 30. Again, let's not fight over 2 million. But let's go back. So the process of probate, you said what it is.
Yes.
So what's it look like? God forbid, I die today. I have a will.
Yes.
My poor wife has to now go through probate. What's that look like for her?
So depending on who your nominated executor is, assuming it is your wife,
yes,
she can certainly. People do try to do it themselves. It's not easy, and my best advice would be, if you do have to probate a will, just spend the money on an attorney and let them handle it. Because not saying that as an seriously, it is a headache that even I get frustrated with. Right. So
I'm not an attorney. I make no money. I agree with you 100%. I dealt with 2 parents.
That is something that I would leave to the professionals as best as, that's the best advice I can give you in terms of probate. She would have to, number one, take your will and submit it to the courts. They will, with a fine-tooth comb, look over your will, and they will catch any typo, any mistake, anything that they find fishy or suspicious, and ask about it. And we have to, if we get those come in, and they do come in,
Right.
there are typos made. Attorneys are not perfect. It happens. And we have to do affidavits and track people down to fix these issues. So if your will, every other spot says executed in 1985, and then one spot at the end says 1988, I'm going to have to track down the attorney that drafted your will in the 80s, find him, and ask him to sign an affidavit saying that that was a typographical
He's now
error.
dead. What happens?
Yeah, that's an issue. This is what happens. I then have to ask the court for to dispense with the testimony of the deceased attorney draftsperson, or find the witnesses, because every will has two witnesses and a notary. So I've gone every single one of those people. I've had to do. I've had to find a witness. I've had to find a notary. I've had to find the attorney draftsperson. So it happens a lot, and so you have to make sure all those issues are fixed. That's kind of the court's job to find those and tell you about it. If you catch it early, you can get out ahead of it. But honestly, I would usually just submit and wait till they catch. Because you can get away with some stuff. The courts are not perfect themselves. But that's not the best strategy. We will look at it and catch it and see if we could fix it beforehand. But it's always not the end of the world if the court says, hey, this is wrong.
So things that they find, inconsistent dates, that I understand. How about a misspelling of someone's name?
Yeah.
Because I had that.
Yeah, it's definitely something that, again, most of these issues are fixed with affidavits. Find the person who drafted it, find the person who witnessed it, and ask them to sign and see if they recall this happening. And then it's up to the court's discretion to see if they feel that's enough to say okay to this will. And that's just the will document itself. You have the whole there's a whole nother beast of your distributees. Administration in New York, your distributees are determined.
Explain what distributees are.
Distributees would be who your heirs are, who gets your stuff. So if you pass today, your wife and kids are your distributees. That's the general. If you have a wife and kids or a spouse and kids, they are your distributees. Now, just because you have a will saying, I want everything to go to my neighbor Joe, doesn't mean that only neighbor Joe has a voice. Your distributees are still required to be present and sign what's called a waiver, saying that we are okay with so-and-so becoming the executor of this will.
I don't say to sign a waiver. I knew they had to be notified.
They have to sign. Well, yes, it's sign a waiver or served and cited in court. So you have two options. You either, in your example, if your wife is going to be the executor of your will, your kids would have to sign waivers. Or if they don't sign waivers, let's say one of them says he doesn't agree with your will, or one of them can't be found, we have to serve them and say, the court gave us this date. It's called the citation date. We asked for it. It's proposed, and then they give it, and then we serve it on the people who didn't sign waivers. And so we say, on this day, March, whatever, you are to show in court and make your, objections if you have any. And so that's right there is a 1.5 to 2 month delay.
That's a good reason to write a trust right there.
And then we have to wait for the court to give me the date, and then I show up to the date. I bill all of our estates hourly. So if I have to show up to court for you, and God forbid it's Riverhead, you're talking 4 or 5 hours of billed time for showing up to a citation date. So waivers are crucial.
I'm going to ask you a question, which is kind of a nuanced question, but I know when being a real estate guy, we have to deal with evictions periodically. And if I show up without an attorney, I'm in the back of the list. When the people show up with attorneys, they get taken up front. Does that work in this case or no?
Nah.
So you could wait there all day.
Honestly, the citation dates are typically pretty good if you just have a standard distributee who couldn't sign a waiver. They just go right down the list. Boom, boom, boom. They call you one case after another. You step up. You see that the person didn't show. And if the person doesn't show, that's usually as long as you have proof of service and valid service at that, they'll move forward. And
I assume they normally don't show if they're not going to object.
But they show sometimes.
Those are the ones who object. When they show, it's bad news.
Sometimes, again, a lot of people don't understand this process. So they think like something really bad's happening, but it's really just like, hey, do you want to be involved in this, or are you okay
Right.
with your brother handling everything type of thing?
Right.
And then they show up and they see what it's really about, and then they kind of just go back into the wind, right? And just wait for their check to come.
Right. Wait for the check to come.
That's kind of one that I had recently. It's a little more nuanced than that, but the mom dies and there's 3 siblings, and one of them does not get along with the other 2, and so she showed up at a citation date that we did not expect her to. And I ended up spending like 2 or 3 hours conferencing with the court and her. She was unrepresented, and so unfortunately for my client, that's all billed time.
Right.
And she ended up pretty much going into the wind. She heard everything she needed to hear, and she at first expressed interest in buying out, and none of that came to fruition, and so now she's kind of out of the picture.
So she's not inheriting, or she's not?
She's inheriting.
Oh, but she's not in charge.
But she's not in charge, and she's not getting what she wants.
Okay.
What she wanted was, it's a nuanced situation. Right. Her son is living in the house in question.
Okay.
And she wanted to somehow maybe buy it so that he can stay and they can have a place in New York.
Yeah, that's a big deal.
Yeah,
when I dealt with clients who passed, siblings who got along so well aren't getting along once mom or the second one dies. They don't get along anymore because they're fighting over money, and they're fighting over the vacation house, mom's house.
Yep.
Or the one daughter quit her job 10 years ago to take care of mom, and then she passed, and now she's living in the house. And she goes, you owe me the house.
Those are always the hardest to deal with, because they are owed something, and that's not an easy role to give, do.
But they're owed something, but not legally.
Right. Well, it depends.
That's the problem.
Depends if mom wanted to account for that or not.
Right.
If mom had a will from 1990 and you took care of mom from 2000 on and she never changed her will.
Yep. I've heard siblings say.
Technically, if it's equally to all kids, you're not getting a dime for what you did for mom.
Right. You took care of mom, but you didn't have to pay rent. I quit my job to take care of mom.
Right.
It gets really messy.
It does.
It gets really messy. So
it's not easy.
So good. Back for planning. I'm going to use the word back for planning, but we're going through the probate. So now these are some of the issues. Now, what you're talking about is totally avoided with a trust.
Pretty much. You can always end up in probate with a trust no matter what, but hopefully if that ever does happen, it would be for one singular asset that's not that large. Even if it's $100,000, if you saved, $2 million in the house and other assets from going to probate, you won.
Right.
And yeah, you may have to eat an attorney's fee for $5,000 on the $100,000, but at least everything else is safe.
Yeah.
Part of the problem with probate is that our general timeline is 6 to 9 months. And that's if you get a good court in the area.
And that's Long Island or New York City?
I tell pretty much everyone 6 to 9 months.
Right.
Nassau County is really kind of the only one that I've seen you can get closer to that 6-month mark or less, very rarely. The Bronx, forget about it. You're in 9+. And the rest of them are operating within that 6 to 9, but can definitely bleed longer.
I'm dealing with them now in Brooklyn. That's going on years.
Yep.
Years. Yep. 3 years.
As you get into the bigger boroughs, I was sitting in the back of a citation day once, and they called the case with a 1986 index number. And I couldn't believe my ears. But
it's 2026, just for the record.
Yes.
1986.
They called a 1986 index number case.
Okay.
So that's like the super ugly. You're doing accounting for 20 years. And
that's 40 years.
Yeah, well, that's a disaster. I honestly don't know how they got there.
Right.
My hair would fall out before I ever got there. But
you'll be retired.
But it happens. It happens, and it's rather unfortunate.
Yes.
If you ever sit in the back of a citation room, that's where this true stuff hits the fan sometimes, and you can see it's torn each and every one of those families.
Hi, I'm Larry.
And I'm Ben. We're the father and son team of Leave the Key Home Buyers, and we want to buy your house.
We specialize in working with seniors who are transitioning out of their homes, and we understand what you were going through.
So if you're considering selling your home and would like an alternative to the traditional overwhelming process, reach out and see how we can help.
Do you have an outdated home?
No need to update anything.
Have a home that needs repairs?
Don't bother with repairs.
Don't want to take everything with you?
Leave whatever you want behind.
Dreading the headaches that come with agents?
Sell your home without paying a commission.
Dreading prying neighbors, attending open houses and passing judgment on your home?
No need for public showings.
When you sell to us, You'll have all the certainty of closing on your timeline, not someone else's, and there's absolutely no pressure.
Visit leavethekey.com or call us today for a no-obligation offer at 631-388-7771 if you want to sell your home today.
A citation room in front of a judge?
Mm-hmm.
Okay.
Yep.
I
So the
never
judge
heard
will
the term.
call your index number. I'll step up for my client, and I'll basically just sit there and turn around and wait to see if anybody who I had to cite is going to walk up to the bench or to the table or not.
Mm-hmm.
Typically it's me waiting for someone to show or not.
Mm-hmm.
Very, very rarely would it be at a citation date another attorney on the other side with you. Those are typically for like accounting issues and follow-ups with the court.
Mm-hmm.
Usually you're just kind of waiting to see if someone shows.
They're going to make some noise.
Mm-hmm.
And once they're going to make some noise, then they may hire an attorney.
Yeah.
Okay, that's interesting.
And also, if an unrepresented person does show up at the citation date, the court is going to give them every opportunity to get an attorney.
Mm-hmm.
So right then and there, not only did you wait a month and a half or 2 months to just get your court date, if your sibling, if your whatever distributee shows up at that court date, they're going to get another 2 months to find an attorney. And they can show up 2 months after that without an attorney, and the court's going to tell them, okay, well, now we'll just proceed.
Mm-hmm.
And so you just lost basically 4 months because this person didn't sign a waiver for you for whatever reason, and then also decided to show up at the citation date.
Gosh. These are examples I hadn't heard, but I just know the process. It's just a pain in the neck.
Honestly, what I tell people sometimes is, and it's horrible to say because it's typically not what you want, but administration sometimes is a hell of a lot easier than probate because New York State says you get this and you get this.
Right.
And so who's there to argue that? You can't argue that. And sometimes it just kind of works itself out a lot easier and a lot quicker.
Someone just came to me with some estate questions. We're talking about buying her house. And she said, I don't know where mom's will is. I said, how many of you are? There's 2 of us. I said, you get along? We get along. I said, if you split everything evenly, no one's going to complain. She goes, no one's going to complain. I said, then talk to an attorney, find out if finding the will is beneficial or not. She goes, we're not even going to fight because I want my sister to get more money. She needs more money than I do. I said, so it's absolutely friendly. I said, talk to the attorney. And she didn't have one, so I recommended a state attorney to settle up. And he said the same thing. Don't even look for the will.
Yeah, revoke it.
Yeah,
do a simple revocation.
Yep.
And go to administration. It's not the best advice in the world, and ideally I would tell everybody to have something in place, but sometimes it does work out better than...
It was just the 2 girls, and it was just going to go 50-50. That's what the court would say.
Yep.
She would have given one her sister anyway.
Yep.
So, with that in mind, there was some nuance that made me think administration was better. I'd say I don't want to say it here, but the honesty is I don't remember what it was. So that's why I said make sure you talk to an attorney, because I thought, and he agreed. I forgot
Sometimes
the reason why, but
it could be much quicker and cleaner.
Yeah, that's what he said. You'll probably save a few months.
And if you think about it, it makes a lot of sense because the will is a whole nother document, 6 to 10 pages that has to be reviewed, and you just don't have that in administration.
That's right.
It's just less stuff to make errors on. There's less stuff to cause issues.
Yep. So, and it was just the 2 kids, so it was easy.
On top of New York State says exactly who gets what.
Yep.
Sometimes it's rather simple.
Yeah.
But I would still suggest to at least have a will.
Yeah. So with that said, so now today, are people? So the general advice today is go with a trust to avoid probate. It doesn't mean so let's talk about that for a moment. So I die, but my wife off this time. So my wife dies, and we both have trusts.
Yes.
What does that process look like by comparison? Do I need an attorney for that?
So that's an interesting scenario because typically what we do or what we see is married couples having one trust.
Right.
So if the 2 of you had separate trusts, that would lead me to believe that she inherited something from her parents that she never commingled with you, which in fact is something I usually do advise to do.
Right.
Is don't commingle assets, especially if you're able to.
Yep.
Sometimes you can't avoid it.
Yep.
Right. But if she inherited a house from her mom and kept it in a separate trust, then so our joint trusts have language that says this trust does not get, distributed until the death of the second one, because you want the surviving spouse, and the whole goal is to keep those people in their house until they die. Right. So you don't want anything to disturb that, even if one of them goes. In your case, if your wife did pass before you and she had her separate trust can be distributed the next day.
Right.
And you can then decide what you want to do with those assets if you're even the beneficiary.
Right.
I would honestly guess that if she did have that separate
I'm not the
trust, you're not the
beneficiary.
beneficiary, it would be your kids.
We made the kids the beneficiaries.
Yep, exactly.
Right.
So
we do have separate trusts, and we did make the kids the beneficiaries.
so she would, and I'm assuming it's because you guys had someone inherited an asset.
No.
You just did separate trusts.
We want to split our assets.
Nice.
We've done well, and we're afraid of future estate tax.
Yeah.
So with that, in spite of what's going on, I'm not sure the numbers will stay this way, but we'll find out. Supposedly they made them permanent, from what I understand.
What?
The estate tax
the estate
level
tax
today
numbers?
on the federal level, but I don't know. We'll see.
You never know.
We'll see. You never know. You never know what Washington says.
They've been rumored to be. So do you know about the 5-year look back on nursing homes?
Yes.
Okay, so just for those who don't, if you don't have an asset in trust for 5 years, the nursing home can lien that asset, typically the house. So what that means is you can go on to Medicaid services and they'll pay for your nursing home for however long you're there for. But if you die, or when you die, they'll take their bill, they'll turn around, and they'll attach it to your house in the form of a lien.
So Medicaid, not the nursing home. Yeah.
Medicaid. Yeah. Nursing home gets paid by Medicaid.
Correct. So Medicaid wants their money back.
Medicaid wants their money back, and if they can attach it to your house, they will. And that doesn't mean that you're going to get kicked out of your house or a forced sale on your house. But the second your kids go to sell that house, they're going to find out that there's a $300,000 lien for Medicaid that has to get paid first.
Right.
So you can avoid that if you have your house in trust for 5 years. That's called the 5-year look back.
Yep.
They've been rumored for God knows how long to be putting a look back on the community Medicaid portion, which
they don't have in New York.
Which they don't have.
Yeah.
They have the program in New York.
Right, yes.
But they don't have the look back.
That's what I meant.
New York's been rumored to be putting that look back in, a 2-year look back for years, and they've never actually done it. So
why would it be shorter for the community look back, I want? First of all, why is there none? And why would it not be 5 years?
I don't know. These are good questions.
I used to sell long-term care insurance in my financial advisory days. And I used to tell everyone, please buy a 5-year policy. They say, but the look-back period's 3 years. It was then. I said, it's going to change to 5 years. It took about 5 years for them to change it from the time I gave that advice, but it changed.
A year or two ago, there was the whole story about the bill of the look-back being on Hochul's desk, ready for signature, and it had never happened. So I don't know, and I don't really want to speculate, and I'm just going to continue until they tell me that the law changes. I'm just going to continue to properly advise people.
Right.
But
be prepared.
Yeah, that's always the issue is the laws can change on a whim.
Correct.
Especially those in particular.
Right. Yes.
They are tied into funding from the federal government.
The government has no money.
Yeah.
The government has no money. So if they're going to pay for community Medicaid and they can get that money back, they want that money back. If they can avoid paying it altogether, they'd rather not pay it. So they always find reasons not to.
Yep.
So the fact that we don't have it, and I don't know, someone told me how many states have it, but a lot of states have it now.
Yeah, I mean, it's an elective for the states, and whichever way you do elect is typically given back to you via funds.
So another reason to do some planning, another reason to use some trusts. So I think I may have asked the question, but let me ask it this way. A middle-class person here on Long Island, middle-class on Long Island is different than middle-class in Alabama.
Correct.
Okay? So, sorry, Alabama. West Virginia, doesn't matter.
Yeah.
And most of the country, between Pennsylvania and the the East Coast of California. Okay, we'll narrow it down to most of the country, with the exception of Chicago and parts of Texas. Anyway, is there ever a reason why someone should have a will instead of a trust at that point, living here?
Honestly, I off the top of my head can't think of one.
Okay.
A trust, because honestly, what a trust is just a will on steroids.
Right.
It disposes of your assets. It names who you want to be in charge.
And avoids that 9 months.
And it just has added benefits. So you get to avoid probate. You get to nominate guardians in there. You can have the best part about the trust is an underrated part about trust is the privacy that comes with it.
Yes.
Nobody ever sees it unless you show it to them.
If you have one kid, you're not leaving anything to or whatever.
That's it.
He can't fight it.
He can't fight it.
Yeah.
So they are super private. And wills are, this is the other thing that people don't know.
Yeah.
Wills are public.
Which is crazy.
When you die and I file your will, anybody can look it up.
Right.
And the problem that but what we're dealing with today is, and obviously, as you can imagine, companies have figured that out.
Mm-hmm.
Creditors have figured that out. And so we get bombarded, and our clients get bombarded with real estate, I guess call it companies, or people
Right.
looking to, and saying, are you selling? Are you selling? Are
Right.
you selling? And
Right.
and you're like, how do they even know that like this house it's not on the market? So how do they even know about this house? And it's because you're in the middle of a probate proceeding.
Right.
They sit there, they monitor the web surrogates, they see who died and where their address is.
It's cold.
It is cold.
When I just now, matter of fact, I got a contract to buy someone's house today in my email box. This person called me, I don't know, 6 months ago or something. His niece had passed away, and he inherited the house, but he's letting someone live in it. It's been 2 years that it's been going on. He said, Larry, I want you to buy the house. I said, well, you have someone in it. I'll buy it with your tenant, but we'll make some special arrangements. New York City, evicting in New York City.
Yeah, good luck.
Good luck, exactly. It's years.
Yeah.
And you're talking about a house that's, New York City. It's not cheap. You're talking about close to $1 million.
Right.
And I'm buying it sight unseen because there's a tenant in. I can't get in. So he's very nice guy. But I said, have you made a claim? He says, no, I haven't claimed. I didn't put in my name yet. I said, is there a will? There's no will. So I get him an attorney to settle, basically so he can get possession of the house. Because they had to go through the whole hierarchy thing. And he's an uncle, right, who's inheriting the house. No parents, no siblings, no children, and no cousin. So I went to the uncle.
That's where administration gets tricky. That's why you can't tell people just go with administration, because the second you get outside of the world of how it goes spouse and kids, and then it goes parents.
Right.
And after parents, it gets really ugly.
Right.
Because you get into the world of aunts and uncles or their kids. So you end up having to deal with two classes. So even if you had an aunt or an uncle that died before you, if they had kids, they're going to fill their shoes and take what share they would have had. So administration is a slippery slope where somebody who you may never have spoken to before can end up touching getting your assets.
At least they were close.
Yeah.
So I feel better. So, but it got complicated.
Yeah.
It got very complicated. But, yeah. So have all your ducks in a row.
Yeah.
Have all your ducks in a row. It could have been, it took, shockingly enough, the attorney recommended probably do the whole thing in, 4 months. I was shocked. It took that short an amount of time.
Could have got lucky. It's definitely a way for there to be one aunt and uncle, and he's alive, and there you go.
Yeah,
there you have it. That's not horrible, but that is like,
mom had no siblings and dad had one brother.
That is the luckiest I've ever seen it. I just had one recently where a friend came to me with a will of one of her friends, and she said, I've been sitting on this will for a couple of years now. He died a couple of years ago, and I don't know what to do because I don't know any of his family.
Right.
And so I eventually got my hands on it, and I said, look, like you need a genealogist.
Yes.
That's typically how you fix these things. There are people out there.
We've hired one.
Yes. Who will sit there and dig through census records and birth certificates and everything under the sun and put together a report to find somebody's distributees.
Yeah.
And so, it's unfortunate because that's another right there, $1,000 or $2,000 that you have to pay the genealogist.
Yep.
But they will find people. And so this one in particular ends up with like 9 first cousins.
Yes.
That are, so because there's a will that leaves everything to the friend, they're not getting anything, but they have to still sign off because they're considered distributees. And when you think about it, if you're one of those people, why in the world would you give that any time of day? You're not getting anything from it. So you signing a waiver and helping out the friend of a cousin that you didn't know even existed.
Yep.
There's no point. If I was in their shoes, I completely understand.
So where there's a will, there's a way of paying an attorney more money.
Yes.
So avoid the will. Interesting. So am I paying more money to write a trust than a will?
Yes.
Okay. Trust
a
is more?
significant amount.
Okay.
Typically about double.
Okay.
But
but I'm not paying for probate
Exactly.
if
That's
I
the
do everything
catch.
properly.
That's the catch. So if I
And
charge you for a will
Right.
for, let's call it 3,000,
right,
but then you have to go probate, your kids have to go probate that will for 5 or 6, now you're in for 9 or 10.
right,
Whereas a trust can cost you 7 or 8, and
Right.
and so
and make life easy.
exactly. And the other thing I tell people, it's really a matter of preference. You know, a lot of people, I hear one of two things. It's either I don't want my kids to have to pay for anything after I die, or it's I don't care, I'm dead already.
That's right.
And I understand both ways of
I do
thinking.
too. I do too. But I've said this many times. Said this for 30 years prior to being in this business and doing the podcast, and that is inheritance is a consolation prize. So my mom and dad are gone, but you got this parting gift, a lifetime supply of rice-a-roni, and $1 million. You know, and that's sort of what it is. So they get a lifetime supply of rice-a-roni. I'm dating myself. You don't know from the game shows. That's what people get. I just want to know what a lifetime supply of rice-a-roni actually is. But so you get, and you got $700,000. I'm talking with someone now. A woman had no children, no spouse, left money to 23 or 26 friends. Let me say, 23 or 26 beneficiaries. I'm dealing in a house full of 4 or 5 friends. And it was such a mess. The actual executor stepped down. She didn't want to deal with it. And I went to
I'm
number
glad
2.
you brought up that scenario because that's a whole nother issue with wills. We try to insist on, when we just do wills, a couple things we try and tell people. One of them is if you can avoid leaving specific items to people,
Right.
don't put it in your will.
Right.
Because
That's
God
interesting.
forbid anything happens to that item,
Right.
and then now it's sitting in a will, the beneficiary is going to be pissed if you left the ring to me and then the ring can't be found.
Right.
And there's really no way to fix that.
I never heard that.
The
That's
other
interesting.
issue is if you leave specific dollar amounts to people
Right.
in a will in
You don't wanna do that.
1990 and then you die in 2020 something and
The
you
dollar
don't
amounts are going to be different?
yeah, you don't have the money that you
Right.
said you were leaving to people. Well, now everyone's got to get a prorated share of
Right.
of what they were supposed to get, and you can imagine that is not something that is cheap.
But I've heard something to add to that. If you leave money to charity, leave a dollar amount. Otherwise, the charity can audit the estate.
Yeah,
Versus-
what I do typically
yeah.
see is dollar amounts to charities.
Right.
Yes.
Don't say I'm leaving 10% to blank, blank, blank
Because
charity.
if there's no money for the charity, then they'll take a prorated whatever, and,
Right.
and at least they get something. And yes, but we try and really push percentages.
Right. For people.
Yeah.
Right. I couldn't imagine doing it any other way.
Yeah.
I couldn't
Or,
imagine.
you know, if you want to leave like $5,000 or $10,000
exactly.
to a grandkid or grandkids, that's fine. As
Yes.
long as if I see that you have,
Yes.
that I think that money's going to be there, I'll say okay.
Correct.
But to your kids, everything else, percentages.
Those are bequests.
Yeah.
I don't call those
Yes.
inheritance. Those are bequests. I don't know if the terms really mean the same thing, but I distinguish them by my own personal language that way. You want to
That
bequeath
is the
$5,000
correct
or
legal term.
$10,000 to them, but your kids are inheriting the rest.
Yes.
Like that's different than the bequest.
Yes.
That's the right term. So
That's the perfect legal term. That is
okay,
what it's called.
There you go. So with that, and I should have been a lawyer, but my parents would have been so proud. My father wanted to go back to law school when my father wanted to go to law school, not back to when he was 60. Because maybe I should go to law school now. He had the mind of a lawyer, but no legal education. But he would have been a good one. But putting that aside, you can't see any reason to anyone to write, any person with any level of any means whatsoever, possibly even people without, to write actually people with very little. Even that doesn't make sense. If you're gonna write a document, even if you have to pay more to write the trust, I'm trying to think what person wouldn't write. I asked like a middle class person on Long Island, would a less than middle class, if you're gonna do any planning at all, would a person with few means, still go with a trust?
No.
Okay.
I said there's definitely
I have an answer.
alternative ways.
Right.
Recently, they've come out with the transfer on death deed.
Yes, I was just going to say that.
It is a useful tool and saves you a ton of money.
It's like getting a beneficiary, like an IRA beneficiary.
It's exactly like putting a beneficiary on a bank account.
Right.
Which is great. The only thing that we tell people, and I just had one in our office this morning who decided to go with the transfer on death deed over an irrevocable trust.
Right.
Is that we don't know the fallout yet. It's brand new.
Okay.
And so there's the litigation cases, if any, are small.
Right.
We don't know
Right.
how they're going to work yet. They're not, again, they're brand new. So not many have gone through the system yet. Not many have been processed, and it's kind of I would call it like a calculated,
Yes.
kind of risk.
It makes so much sense why there weren't beneficiaries on
Yeah.
non tax deferred accounts. I don't know. Non-qualified annuities that beneficiaries, qualified pension plans that beneficiaries. Why can't my bank account? All these years, it seems crazy.
Have you ever heard of an heirs at law deed?
Yes.
So
Yes.
similar concept, except it's more so, mom or dad didn't really do the right thing, but
Right.
we got lucky that there's an heirs at law deed.
Yes.
You can't have a will.
Right.
Absolutely cannot have a will. So
Right.
you'll be looking at administration, and if it's a house, it has to be a house. It's
Right.
called an heirs at law deed.
Right.
If you and your brother are
Right.
inheriting from mom the house and you don't want to sell, that's
Right.
the big part, is you don't want to sell, you want to keep this thing, you can quickly do an heirs at law deed, and a title company will generally insure it for you.
I thought you had to wait 2 years.
You have to, they prefer that you do hold on to the asset for a certain number of years and not
Okay.
just flip it. That's the
Oh,
catch.
because I'm the buyer typically, so they have to wait 2 years to sell it to me.
Typically that's,
Right.
and so
Yes.
that's usually not what people want.
Right.
Usually people do want to sell. So
But when people come to me, they say we inherited mom and dad died 2 years ago, or mom and dad died, and there's no will. And first question I ask is, when did they die? When did mom or dad die? The second one to die. They died 2.5 years ago. I say, okay. And then I talk about the heirs at law. If they say, 6 months ago, I can't use
it's really
that.
up to a title
Yeah.
company. If you find one that insures it, great.
Right.
But
yeah, I know the one we
they
use.
get a little funky with it sometimes.
The one we use, they want the 2 years.
Yeah.
And I know we can always shop title companies.
It's very niche. It's very,
Yeah.
You don't see them a lot, but if there's a chance for it, it's a useful tool.
Okay. I didn't realize they can do it right away, but they're supposed to sell it for the 2 years.
If you tell,
Right.
of course, it's kind of like what you tell the title company.
Right.
But,
Yeah.
but more so, even when you go to sell it, you're just going to have problems. And
Right.
the title company's going to go, so.
Right.
You can imagine that if you tell them one thing and then you just turn around and it's probably not going to go well for you.
Not going to go well for me. But then when I go to sell it, that problem goes away.
Yeah.
But I'm not exposed during the time I own it.
Yeah.
So yeah, it's too big buying any purchase on Long Island. It's too big a purchase to play that kind of game.
Yes.
So I'm going to ask the biggest takeaway. I always ask, what I remember. The biggest takeaway on this conversation seems very, very narrowly focused. If someone turned this podcast on now, and you're going to summarize this podcast, I'm going to say, you could probably do it in one sentence. What would it be?
You need a trust.
You need a trust.
If you own a home,
Yes.
odds are you need a trust.
And this conversation's about probate.
Yes.
But it's really about a trust because the whole thing is avoid probate. There's no reason to go through the 9 months, 6 to 9 months, 6 to a year, 6 months to a year, and go through the expense when you could write a trust instead of a will. And now those people that have a will already, it's still worth writing the trust. Even though they paid for a will, they're paying for a trust. So their kids or spouse or whatever are going to avoid the probate process.
Yeah, one of the biggest barriers are that people, and I get it, I totally get it, but people don't like to discuss this.
Yes.
This is not something that people are comfortable with admitting that they need. They think everything's fine. And then on top of that, when I sit down and consult with them and hit them with a $7,000 or $8,000 price tag, it's like, well, what? I don't need this.
Right. I just was at a meeting. I'm part of a financial group out of Dallas, and they were just talking about family offices, but small family offices. The people with like $5 million. That's not really a family office, but it operates like one. A family, so where you have family values and you have use of money and you talk about all sorts of things, but they say, when do you start talking about money with your children? And that was a whole big discussion. I started talking about with my personal experience, and then my internet went out. So no one got to really hear. But anyway, they came on literally as everyone's saying goodbye. I said, goodbye. I didn't hang up on you or cut you off. It was the internet company that did it. But I wait till my kids were in their probably late 20s and 30s to talk about money with my children. My son is my business partner. He knows more about my money than I know about my money at this point. But some people talk about the kids when they're 12 and 15 years old. It depends. It depends on your kid's maturity level.
Definitely.
Depends on your kid's maturity level. And also giving money to children while mom and grandma and grandpa died. Do you give money to kids? I gave a good part of my inheritance to my children. I knew it wouldn't change who they were. I raised them right. And it didn't change them at all. And So money's a very, it's a very logical topic, riddled with way more emotion than logic to it.
Yeah.
I mean, money should have no emotion attached to it, but it's riddled with it.
And everything that you just said is addressed and with a, defined kind of, way of going about it inside the trust.
Right.
You dictate what age your kids get the money.
Right.
You dictate how much money they get. You dictate this, you dictate that.
Yeah.
One of the biggest hurdles, like, other than, the I don't need this, is the what do you mean I'm no longer in charge of my house and an irrevocable trust? Like, because you're removing the person's name off their deed. And that sounds like it's not a big deal, and it's really not.
Right.
But put yourself in the shoes of the guy who's 75 and owned this house for 40 years.
Right.
You think it's easy to get that guy to sign a piece of paper to remove his name from the deed? No way.
But that's the easier part.
Yeah.
It's the actual accounts that are harder.
Yeah.
When I have to, the old line,
the deed's easy.
I'm gonna have to ask my kids for money. I have to ask kids for my money.
Yes,
that's a non-starter.
And that's
for many.
always a funny conversation because it doesn't just automatically become that.
Right.
If you don't need Medicaid, you don't need to have everything inside of a trust. Right. Medicaid has certain qualifications that you need to meet to get their services.
Yeah.
But if you're a fully healthy 75-year-old man, there's no point in pouring all of your money into trust just yet.
Right.
Now, obviously, it's tricky because you want to play by the 5-year thing and make sure your money's locked up and safe.
You also may have too much income. You may have too much income, which can't be.
Income's a whole other
between you're a civil servant. You and your spouse have pensions from the government, and you have both Social Securities. That you disqualify right there.
Yeah.
You can have all the assets you want, and you're not going to. You can have zero assets. You're not going to qualify. So at that point, you don't worry about Medicaid planning. You worry about estate planning from tax perspective. You worry about probate issues and so on. Also, one last comment I want to make about probate is going through the process is expensive and time consuming. The problem is when all the assets go through probate. And I've seen this so many times where literally everything's going through probate and the house needs to be maintained.
Yes.
And now who's paying the $15,000 worth of the $1,000 or $1,500 a month on taxes? My oil bill right now with this cold weather is running like $700 a month for my house. So who's paying all of that?
So it's funny because they tell you, and it's true, you're not personally responsible for a dead person's debts.
Right. Except,
you have to use their money first to pay their debts. That's number one. And so I just ran into that situation this morning.
But you can't get their money if it's going through probate.
Number one, you can't get their money. Number two, if you have a sole beneficiary who's also serving as executor, they're basically just using their money, that's the inheritance, to pay the debts. It's a tricky situation because, yes, technically it is the deceased person's money and it's their debt, so it should be paid. But in other instances, people wouldn't be affected by that, but that singular person is.
Right. That singular person just may not have the cash. I've seen that so many times.
To maintain
Can you buy the house
property
now? I can't afford it. And I said, I can't buy the house now.
Yeah.
You don't own it.
It's very sad.
It's very sad. And they talk to the bank. We try to.
It doesn't matter. You can't do anything about it.
Exactly.
You can't. It's stuck in probate.
It's stuck in probate.
The only thing that we can do, that we try to do, and I'll say it's, probably like 50-50 is you can always ask the court for relief, of course, right? In any form of relief and leave it up to them to decide. So number one, they give you a way to ask for preliminary letters, gives you the ability to do some things early. Number two is, and the typical ask that we do is either A, can you rush this for us because of a foreclosure issue, or number two is, can you allow us to sell the asset and keep the money in the attorney's escrow account?
Well, that seems like a reasonable thing to do.
It seems like a reasonable request, but the courts are sometimes hesitant on it, or they will give you the letters allowing you to do so, but restrict it to the dollar amount.
Right. Oh, really?
Yeah. So that's the new thing that the courts are starting to do here in New York is they are starting to restrict letters and put specific language in the letters that may stop you from having carte blanche. It may stop you, like it may say you can only collect up to $300,000 in assets, and you may think there's only $300,000 in assets, but you don't truly know because, again, the banks will freeze you out. So if you end up getting into the bank account and there's $400,000, well, guess what? You're back in court asking them to lift the restrictions
Mm-hmm.
and reissue letters.
And you chose to do this, why?
It's a great question. My honest answer is that when I worked for a personal injury firm, obviously I was helping people with injuries get their money, but it just didn't feel like that. It was a very different feel. And when I started working first with my externship and then the internship, I just realized that like I'm doing good by almost all of these people, right? I'm doing what they need and what they want. It's like I've very rarely, since I've been in this field, had a client who like left unhappy.
Right.
Like generally they leave the door knowing like, okay, great, I took care of this and I can put my head on the pillow. I very rarely get the angry client calling me and yelling at you, which you will get in other fields.
Yeah.
So I think that kind of fueled my like, okay, I think this is the right field for me. Because at the end of the day, like I just kind of just want to help people, you know. I don't. That's my everything I do is kind of helping somebody,
right?
And without me, who knows where they would be,
right? I was going to have my next question. You just answered. What differentiates your company from other people who deal with probate and so on?
I would say you know, and obviously these things are like, you hear this a lot, it's kind of cliche, but like right now, you know, our company, I'm the lead attorney on our estates. Now, obviously, you know, Christina Sammartino and Leslie Sultan will help me and advise me and guide me because I'm still new. But if you hire us to do your probate, you're getting me.
Right.
And so I'm the person you call and speak to on the phone. I'm the person who does your paperwork. I'm the person who goes to court for you.
Right.
And so people like that.
Right.
You know, they like to call and say,
right.
They don't like calling and getting Joe one day, Jill the next day, and Frank the third day, right?
Yep.
So
they get continuity.
Right.
Someone at the top of that department. And I'm not going to use a number, but right now you're working on dozens of cases. So it's not like you're dealing now and then you deal with probate case. You're dealing on dozens of probate cases right now. There's a lot of waiting time between, I'm sure.
I would say I currently have about 40 or 50 cases, maybe like 40 cases active in court, another 20 or 30 at the point where it's like letters are issued, but you still have stuff to do in terms of assets and other things. So yeah, I mean, we're all over the map. We have some that right now are just hired yesterday, and we have some that letters were issued 2 years ago, and we're still working through some things. Yeah. So
it's a process. It's a process. So question, so how do people get hold of you?
So there's various different ways. Best way is you can call our office number. And this is what goes back to my answer from before. You call our office number is 631-505-1086.
Say that again?
631-505-1086. You're going to get Samantha.
Right.
She's our only receptionist.
Right.
And so you're going to get Samantha, and she sits at the front desk. And then, you know, once you get Samantha, she'll look for me. And if she can't get me, she'll take a message, and then I'll call you back.
Right.
So you get the same person every time you call our office, and then if you ask for me, you'll
it's
get
not
me.
a bot saying press one, press two.
So you know, we're at that point where we're growing and we're getting better at what we do and larger by the day, but we're also small enough where it feels like you get like a hands-on
personal experience.
You get a whole team working for you, and you end up knowing like the 5 or 6 people that work in our office every day.
Right.
You end up knowing all their names, and so you know, that's nice for people. They know that they can. If they can't get me, they can get, you know, our main paralegal, Stephanie. And so it's just, it gives you like that family vibe.
Right. And if they wanted to find you on the web?
Yeah. So you go to sslawgroup.com. That's Sammartino and Sultan Law Group. Christina Sammartino and Leslie Sultan are the founding partners. We have a nice website with all of our information. I'm currently their senior associate, I guess, at this point, or just associate. But they are growing. They are looking to, we are always making new hires. And so we have a couple of things in the works. We're going to try and get into Florida, hopefully.
All the New York attorneys do that.
Yes. I am planning on taking the July bar in Florida. So that's kind of our next step in terms of growth. But yeah, I mean, right now we're in Lindenhurst and Wantagh. So we also have an office in Garden City. So we're all over Long Island. We deal with everything inside of the 5 boroughs. So and we've even done some probates and administrations for upstate New York. So any issue that you have, you know, even if we can't help you, we can connect you to the right people.
That's what we do in our business. Yeah. That's what the whole podcast is about, to introduce people to the public who need people. So anyway, So I thank you so much for coming.
Thanks for
having me. It was a
having
real pleasure. Thanks for listening to this episode of the Unlocking Senior Resources podcast by Leave the Key. If you've enjoyed this episode or found it helpful, don't forget to subscribe, leave a review, and share this podcast. We specialize in working with seniors who are transitioning out of their homes, and we understand what you are going through. So if you are considering selling your home and would like an alternative to the traditional overwhelming process, reach out to see how we can help. When working with us, you can sell your home in its current condition, there is no need to remove unwanted items, and you control when the house is sold, along with so many other advantages. Visit leavethekey.com or call us at 631-388-7771 to learn more about our senior home buying process.